Welcome to another edition of Inside Rosenberg and Estes. My name is Dave Lorenzo, and today our topic is deeds in lieu of foreclosure. We are talking about this subject so that you know what your options are if you're struggling with your debt service on a property right now. If you're a lender and someone has approached you about a deed in lieu of foreclosure, we're going to cover that topic as well. And if you're concerned about the title implications of a deed in lieu of foreclosure, we're going to talk about that on today's show as well. I need to remind those of you who are listening, those of you who are watching, today's show is for informational purposes only. We are sharing this information so that you can do more research, and that research should involve calling an attorney and seeking legal advice. What you're getting from us today is not legal advice. It's just informational content that you can use to begin your process of doing research into this subject. If you'd like direct advice on this topic, we will be sharing information with you at the end of today's show, and you'll be able to reach out to qualified attorneys who can help you with the specific facts of your case. Legal advice is something that you pay for, and you get to have a conversation with an attorney. This show is just for informational purposes. That being said, let's take a moment and introduce you to the people who are going to share the information with you on today's show. First up is Jason Bergman. Jason is a Vice President and Senior Underwriting Counsel at Benchmark Title Agency in White Plains, New York. He's recognized as an industry leader in insuring foreclosures and distressed assets. And he also has extensive experience in assessing and mitigating risk in complex transactions and ambiguous situations. Among his professional activities, Jason is three-term chair of the New York State Land Title Association's Law Committee, vice chair of the American Bar Association Real Estate, Condemnation, and Trust Litigation Committee's Title Insurance Subcommittee, and co-chair of its Mortgage and Foreclosure Subcommittee. This guy knows his stuff, and he's busy as all get out, so we're lucky to have him. Next up is Rosenberg and Estes' own Richard M. Richard concentrates his practice on complex commercial litigation, and he focuses on creditors' rights in real estate disputes. He has extensive experience in all aspects of real estate litigation, including commercial foreclosures, lender liability claims, title issues, property disputes, mechanics liens, contract and joint venture disputes, construction claims, you name it. If it's in the area of a real estate dispute, Richard can help you with it. Prior to joining Rosenberg and Estes, he was counsel with Stein, Adler, Drawbacks, and Zelkowitz, LLP. While attending law school, Richard served as a judicial intern for Judge Robert Patterson in the Southern District of New York and Judge Frank Altamari in the Court of Appeals for the Second Circuit. These guys know their stuff, and we're going to grill them today on deeds in lieu of foreclosure. Let's get right to it. So, Jason, tell us what you do all day. What does your job entail?
My job entails navigating a law school exam question. It starts with one subject and leads into another. So I'm a real estate attorney, but I also have to know about taxes. I have to know about estates and trusts. I have to know about land use, of course, but contracts, pretty much anything that we can encounter that may affect a property, even tangentially, comes up for me every day. It ends up on my screen, some obscure question about a procedural requirement. What was a tax map in 1950 versus 1973? Can you tell me the difference between survey requirements in the past 30 years? Anything relating to real estate somehow comes to me, which is what makes what I do fascinating, because it is not a form and there's no one day that is the same. Every day is sort of an off-script kind of afternoon where people are asking the most random questions, looking for the most obscure knowledge. And that's not to say that I alone possess it, but the title industry, that's kind of what we're here for. Sure, we love to see the vanilla things that come across our desk. Yes, you need to sign the deed, a simple question like that, but that's not what really comes our way. So if it's something unusual, something irregular, something that a group of some of the smartest attorneys you can imagine, after they've spoken about it for days, have scratched their heads, they come to us and say, what do you think about this? And again, that's not to say that I or we are so special and titled, but we're here for those oddball things, the irregular, and the things that just you don't see every day. That's kind of what we do see every day. So,
all right. So you have that specialized knowledge in the area of title. That's why you're joining us today. Richard, tell us about your day. What do you spend most of your day doing?
Well, mostly I represent lenders and borrowers in dealing with defaulted loans. So I'm enforcing loans and loan documents and foreclosing and or getting involved with workout discussions on behalf of both lenders and borrowers. So I'm just trying to figure out solutions, and that's a good way to sum up what I do. I really try to find solutions to problems and to problems arising from defaulted loans.
So, Richard, what is a deed-in-lieu?
So a deed-in-lieu is a workout tool. It's when a borrower in a defaulted loan situation agrees to give the lender a deed to the property. And this is just one of many workout tools that can be used when a borrower is in default.
So when you say a workout tool, that means that it could avoid the foreclosure process. Is that what we're talking about?
Yes, absolutely. So most borrowers know before a default under the loan that there's going to be a default. The property, they could have lost tenants, for example. They're not able to meet their debt service requirements, or the maturity date's coming up for the loan and they can't get a refinance loan out there because the credit markets are frozen. So there can be a lot of situations where a borrower will know that it's upcoming on a default, and where the lender also knows where the borrower is in trouble and they're going to have to deal with a defaulted loan situation. And when you have that type of situation, there's a lot of different workout scenarios that can take place. And there's a lot of different tools in the real estate workout toolbox that you can use to work out a defaulted loan.
All right, Richard. So let's say I'm the borrower. What are some benefits to me for doing a deed-in-lieu?
One of the primary advantages of a deed-in-lieu is debt forgiveness, which is where the lender agrees to forgive the remaining balance of the loan if the property is transferred to the lender via a deed-in-lieu. If the lender agrees to forgive the debt, the borrower will be able to essentially walk away and not be liable for a deficiency judgment if the total amount of the owed under the loan exceeds the fair market value of the property. However, this is not always the case, and the borrower must negotiate this aspect with the lender. Another advantage is that a deed-in-lieu is discreet. It avoids the negative publicity that comes along with a foreclosure action. Especially in these times of distress in the real estate markets, we're constantly seeing headlines in the news discussing rising numbers of loan defaults and foreclosures. So unlike a foreclosure proceeding, which is a matter of public record, a deed-in-lieu is completed by private agreement, and the terms can be kept confidential, except for the actual recording of the deed. So for a commercial borrower, avoiding a foreclosure action can be important because going through a public foreclosure proceeding can damage the borrower's reputation within the real estate and business community and with its lenders, customers, partners, and potential investors. A deed-in-lieu also saves on legal fees and costs incurred in connection with defending against a foreclosure action, and allows the borrower to avoid the time and energy spent in dealing with a lengthy and often stressful foreclosure process. So these are the primary advantages of a deed-in-lieu for a borrower.
And those are not insignificant. You can save money. It's discreet, avoids negative publicity, and you could potentially be released of your deficiency judgment. And there is the potential for debt forgiveness. So, Jason, let me ask you, can just any borrower enter into a deed-in-lieu?
Good question. So any borrower is permitted to seek a deed-in-lieu foreclosure as an avenue to explore for remediation, but no lender is under an obligation to grant the deed-in-lieu. Now, the makeup of the borrower may dictate certain options that exist or steps to consider. So for example, if we're dealing with an entity, so not your vanilla transaction where you have an individual that's going to convey title to the bank via deed-in-lieu, but you have an entity, be it an LLC, a corporation, irrespective of the makeup for title purposes, we're going to require the full consent of all members. And that's even if the underlying formation documents say otherwise. And that, of course, goes without saying, unless, of course, there's a bankruptcy court order. So for title purposes, if we have a bankruptcy court order declaring that less than all members' consent is required, we will accept it. In the absence of that, notwithstanding the documentation, we're going to need to see all of the consent of all of the members. I'd like to add a word on religious corporations. Religious corporations who are borrowers, if they are going to deed the property to the lender, that then court approval is required for that transaction. If a religious corporation is the lender and they accept a deed in lieu of foreclosure, the acceptance of that deed is not subject to court approval. Another consideration when you're dealing with the nature of the borrower is also, in some instances, the nature of the loan. So if you have a HUD or FHA loan, then the deed in lieu, while permissible, cannot be entered into or even applied for until several other measures are first exhausted. So parties with that type of loan would be best to look at the Mortgagee Letter 2014-2015, which was implemented by HUD in 2014, and lists all of the requirements for real estate agents, brokers, listing periods, and other myriad requirements before they will consider a deed in lieu on a HUD or FHA loan.
Okay, so that all sounds great. Richard, are there any drawbacks or disadvantages for a deed in lieu if you're a borrower?
Yeah, there are. Apart from losing the property and the negative effects that come along with that, a major issue for a borrower is the potential tax liability for cancellation of indebtedness, or COD income. If you're considering a deed in lieu, it's very important to consult with your tax professionals and legal professionals because there are tax implications of debt forgiveness. The IRS may treat the cancellation of debt as taxable income to the borrower, which could result in a tax bill unless the borrower qualifies for an exclusion. So, debt forgiveness after a deed in lieu can result in a significant tax bill for the borrower, which can be a very unwelcome surprise and a significant burden, especially if the borrower is already in financial distress. There's also a potential tax liability for capital gains tax. Again, you need to consult with your tax professional. There's also transfer taxes. In a regular sale of property, the seller or the grantor is required to pay the transfer taxes. However, in a deed in lieu situation, will the lender agree to pay the transfer taxes instead? This is something that needs to be negotiated with the lender.
All right, so you mentioned transfer taxes in there. Jason, tell me, do transfer taxes apply to deeds in lieu?
Yes, they do. In fact, not only do transfer taxes apply if you're dealing with a residential property valued at $1 million or more, then mansion taxes will also apply. But if we're strictly talking about the commercial setting, transfer taxes absolutely apply, and that's New York State and New York City. I'll add that the general formula for determining the taxable consideration for New York State, whether you're dealing with recourse or non-recourse debt, is the same formula, and that's the unpaid balance of any debt plus any other liens affecting the property that will remain at the time of the deed in lieu, and any other amounts paid by the grantee. All of that together is the taxable consideration for New York State. However, if you're dealing with recourse debt, New York State will cap the consideration at the fair market value. New York City uses a similar formula. It's the outstanding mortgage debt plus unpaid accrued interest and any other liens remaining on the property at the time of the deed in lieu, but they do not make a distinction for recourse or non-recourse debt and do not offer a cap at fair market value.
Okay, so we touched on before that lenders obviously are not obligated to accept a deed in lieu. Do lenders like deeds in lieu? What are the advantages and disadvantages of a deed in lieu from a lender's perspective? Richard, why don't you take that one?
Okay, great question, Dave. There's pros and cons of a deed in lieu for a lender. First, I'll speak to the advantages. One major advantage of a deed in lieu for a lender is that it saves time and money and avoids a sometimes prolonged litigation process. For example, here in New York is a judicial foreclosure state, meaning in uncontested foreclosures in New York can take 12 to 18 months easily. If the action is contested, that time frame can easily double or triple. So a deed in lieu also saves on legal fees and costs in completing a foreclosure action all the way to a final sale. And by agreeing to a deed in lieu, a lender can avoid all that time, expense, and uncertainty that's associated with the foreclosure action. A deed in lieu also provides the lender with a faster way to get control of the property and the rental income. So if a property is cash flowing, A deed in lieu will give the lender the ability to capture that rental income and prevent it from being siphoned away by principals or investors. The lender can also install its own management team to manage the property and preserve those tenant relationships and that revenue stream. Very important. A deed in lieu also allows a lender to properly market the property, which should result in a higher sales price instead of what the property would sell for at a distressed foreclosure auction sale. And it can also result in a faster sale. By the way, on this note, a short sale agreement or a discounted payoff or DPO agreement, where the lender agrees to allow the borrower to market and sell the property, is another alternative that achieves this objective. Finally, a lender can also get a release of any potential liability claims to the extent that any exist. So those are some of the advantages of a deed in lieu, but it all depends on the circumstances.
Okay, so let's talk a little bit about the disadvantages for a lender, because if it was all sunshine and roses, they would be doing these left and right all day long, right? There's got to be some disadvantages for the lender. What are they?
Absolutely. So one of the biggest considerations and potential disadvantages of a deed in lieu is that the lender becomes the owner and then has to deal with all the responsibilities that come with owning and managing the property. Lenders want to get repaid on the loan. They don't necessarily want to own the property. So as an owner, the lender will have to hire a property manager, pay real estate taxes, insurance, maintenance, and other costs and bills. There's a lot of due diligence involved, including potential environmental issues. So is the lender willing to become an owner? That's a major consideration. Another potential disadvantage is that a deed in lieu does not convey clean title, and the property is still subject to any junior liens that may exist on the property. A deed in lieu gives the lender the same title that the borrower has. Junior liens and encumbrances will remain a record as opposed to being extinguished, as would be the case in a foreclosure sale and referee's deed. So, is a borrower going to satisfy all those junior liens or mechanics liens or other liens against the property that won't get wiped out by a foreclosure sale? All existing subordinate liens should be negotiated and dealt with as part of the transaction. And so it's one reason why it's important to get your title company involved as early as possible so you can run title and see if there's any junior liens. Another major consideration or disadvantage is that the lender may have to release the owner and any guarantors from any deficiency claims. In most cases, the owner or the guarantor will want a release of any liability for a deficiency judgment or any recourse carve-out claims to the extent any exist. Is the lender willing to release the guarantor? Does the guarantor have any assets? Again, these are all major considerations for a lender that's considering a deed in lieu. And then lastly, we touched upon it earlier, is transfer taxes. So like I said, in a regular sales situation, the seller pays the transfer tax. However, in a deed in lieu workout situation, the lender may have to agree to pay the transfer taxes. And if so, those transfer taxes are going to be grossed up. So those are some of the disadvantages of a deed in lieu.
All right. So as we walk through this, I want to remind the people who are listening, the people who are watching, that Inside R&E is presenting this information to you for the purposes of you doing your research, doing your diligence in order to figure out what the best solution is for your specific situation. This is not legal advice. If you'd like legal advice, we're going to give you the contact information of the gentlemen who are here on the show today. You can retain them and ask them specific questions about your specific situation. And after you retain them, that is when they will be giving you legal advice. What we're sharing with you today is simply for informational purposes, and it enables you to start the process of doing your research to determine what the right options are for your specific situation. All right, so Jason, you live and breathe the world of title, and it is said that deeds in lieu of foreclosure are high-risk transactions for the title industry. Jason, why is it that deeds in lieu are high-risk transactions, and what are the risks that you guys are grappling with when it comes to a deed in lieu of foreclosure?
Sure. So they are high-risk transactions because they are irregular transactions. It is not your normal marketplace conveyance. So it's born out of an irregularity. So already it's a little more complicated than your standard transaction. But really, since we're talking about title claims, of course, we're going to be concerned with any post-closing challenge to title. But here, those that are emanating from claims of improper authority, an attack on the nature of the default, if there is a problem with the property versus debt value, which we'll get into, and the worst case scenario, which would be that the deed in lieu is viewed not as a conveyance, but rather as a security instrument or an equitable mortgage of some sort. All of those positions would be untenable for any title company.
Okay, so how do the parties get into a deed in lieu transaction? How do we enter into this? I mean, it's not as simple as just walking into the lender's office and throwing the keys on the desk and saying, "Hey, I'm out." I mean, how does it work? What are the requirements? What does the process look like? Richard, go ahead and take that one, please.
So usually it's the borrower that initiates the conversation with the lender, and this can happen directly between the parties or through their counsel. Lenders are under no obligation to accept the deed in lieu, like we mentioned before. In a lot of cases, the lender may prefer to just proceed with a foreclosure action or other alternatives, such as a forbearance, a short sale, consent judgment of foreclosure and sale, rather than accept the deed in lieu. So a lender's decision will depend on the property's value, whether there are other liens against the property, other lenders in the capital stack, the borrower's financial situation, whether there are any guarantors that are viable, and whether there are any recourse liability claims that have been triggered, and the lender's overall potential to recover the balance of the loan. Again, it's critical to consult with your attorney as early in the process as possible to carefully examine all the pros and cons and potential pitfalls with the deed in lieu, regardless of whether you're a borrower or a lender. It's also very important to order and update the title search at the start to get your title agent involved in the process, because there's complex title issues that potentially come into play. So if both the lender and the borrower are agreeable to a deed in lieu, parties will then start the process of preparing the documents, which generally include a deed in lieu agreement, a deed in lieu affidavit, and an actual deed and the conveyance documents that go along with that.
Okay, so when you're getting your title agent involved, Jason, how do we guard against the title risks associated with these transactions, the risks that you mentioned before, and what are the resulting title requirements?
A lot of paperwork. That's how we guard against it. And I'll add, though, that while we do expect a lot of paperwork, it should be effectively identical to what's already in the lender's file. So a lot of the risks and concerns are the same on both sides, the title and the lender side. So the paperwork that we want should already exist, although there are certain requirements, buzzwords that we're going to want to see in specific representations, which I'll get into, and that is how we guard against the risks. But as a starting point for title purposes, there's two conditions that first must be met. One, there must be an actual default. What I mean by that is we want the traditional default to be the reason that there was a default under the loan, and therefore the conversation that led to the deed in lieu negotiation. So that means we want a non-payment under the terms of the mortgage, not a technical default such as violating a covenant made with the lender, such as agreeing not to convey title without their authorization or something similar. So again, I'm not suggesting that that is not a valid ground for default. It is, but for title insurance purposes, given the high risk involved, we want the default to be attributable to non-payment. The next requirement is that the property is underwater. So simply stated, the debt must exceed the fair market value. Once those two hurdles are surpassed, we are ready to proceed with all of the paperwork. Now, I'm going to go through the titles of some documents. That's more form over substance. In the end, we need to have certain representations made by the borrower to the title company. It should not matter what the title of the document is that contains those, but I'll mention where we expect to see these representations as it's the most common form. So first and foremost, the most important document is going to be a deed in lieu agreement. This is going to detail the history of the mortgage, the default history, certainly going to indicate the terms under which the parties have agreed to make the conveyance, accept the deed in lieu conveyance. It's going to include a statement as to the consideration, which is the full cancellation of all debts and the forgiveness of all obligations secured by the mortgage. We're also going to want the borrower to tell us that the conveyance is an absolute and unconditional conveyance. So that means that the borrower will not retain any right to repurchase the property, will not have a right to retain the property after the conveyance, no right of first refusal, no right to use or control or develop the property. It needs to be that the borrower is walking away from all rights, title, and interest in the property. So those representations are what need to be made in order for us to ensure that it is an absolute and unconditional conveyance. If that's not the case, the court could deem the deed in lieu to be a security instrument, which, as I mentioned before, is untenable for the title company. So also the borrower has to be entering into this agreement voluntarily. Obviously, we don't want there to be any coercion or duress, otherwise that could lead a court to set aside the deed-in-lieu transaction as well. The borrower will have to waive any rights of redemption. Some additional representations and provisions that we expect to see in a deed-in-lieu agreement, but again, they can appear elsewhere. This would be the time for the lender to establish that it can take title through an affiliate or subsidiary. It does not have to take title in the same name as the lending entity. This would also be a good place to go through the closing costs, the deliverables, and other closing mechanics to highlight all of the obligations. And as Richard mentioned, also who's going to pay the transfer tax. This is where those negotiations would be memorialized. We're also going to want to see a deed-in-lieu affidavit. This is separate and apart from the standard title affidavit with all the, for lack of a better terms, let's just say standard representations. These are going to be specific representations that speak to the deed-in-lieu and also address some of the concerns that the title insurer has in a deed-in-lieu. So for example, we will want a specific representation that the deed-in-lieu is not intended to be a mortgage. The conveyance is what it is. It's a deed in lieu of foreclosure, conveying title, not an instrument of security of any nature. We would also want a representation that the deed-in-lieu is not being given in preference against any other creditors, and that there are no other creditors or whose rights would be affected by this deed-in-lieu conveyance. I recognize that a title search should disclose anything like that, but obviously there could be inchoate liens and other issues that we're not aware of, so we're going to want a specific representation from the borrower. We will want the borrower to also tell us that they're not obligated upon any other bond or mortgage. For the same reason, we don't know what's not of record, so we need their representations to comfort us in that regard. And again, here too, we would want a representation or an acknowledgement what the consideration is for the transaction, and again, cancellation of all debts secured by the mortgage.
All right, so when we were getting ready for the show, you guys were throwing around this term non-merger language. So Richard, let's stick with you. What is non-merger language and why is it important here?
Okay, so non-merger language is in the deed and in the deed-in-lieu agreement, and it's a critical must-have provision of the agreement for the lender. Non-merger language makes it expressly clear that the mortgage shall survive and will not merge into the fee. So this is critical because in the event there's an undiscovered junior lien, or if there are junior liens that exist, it provides the lender with the option to foreclose the mortgage if it's necessary to wipe out any of those junior liens. So you always want to have non-merger language.
So Jason, what happens if this goes sideways, the train comes off the tracks here? What remedies does the borrower have in a deed-in-lieu transaction?
So the borrower is going to be limited to damages upon a breach of the deed-in-lieu agreement. They will not have the option for injunctive relief or court intervention as you would in pretty much any other dispute or matter.
All right, so Jason, what about the lender? What happens if the lender is unhappy? Are there any considerations for them?
Well, I think when a lender is unhappy, they always have the ability to continue with the foreclosure, which certainly the borrower is not interested in seeing. But the lender pretty much gets what they want. It's true for any closing. It's true when they're just doing a standard loan without a deed-in-lieu even being involved. The lender pretty much calls the shots and gets what they want. So for the hundreds, if not thousands of deed-in-lieu transactions I've been involved in, I haven't seen a lender do anything beyond walk away for a little bit, express some dismay, argue with the borrower, and then all of a sudden they're back to the closing table for the deed-in-lieu. So it pretty much tends to work out in the lender's favor.
Richard, you said at the beginning that the lender is basically protected by the mortgage documents. So if things go wrong from a lender's perspective, they just go, well, we got this agreement here, guys. We could just go pursue the remedies under this agreement.
Yep.
Right?
That's absolutely right, Dave. In addition, a lender can also build in additional remedies into the deed-in-lieu agreement to the extent there's a breach of the deed-in-lieu agreement. So the lender can build in additional protections for itself that may not necessarily exist in the existing loan documents, but they have the right to do that as part of the deed-in-lieu agreement. And again, these are all points that need to be negotiated, and that'll go into the final deed-in-lieu agreement and the other documents.
Okay, so why do we need to consult with an attorney if we're considering a deed-in-lieu? Richard, go ahead and take that. Why is having an attorney so important in this process?
A deed-in-lieu is only one option or tool in the real estate workout toolbox. If you have a defaulted loan and you're having potential workout discussions, you need an attorney that's equipped to analyze and explore all those potential workout options. While these can include a deed-in-lieu arrangement, There's a no one-size-fits-all approach. And there are many alternative approaches that could achieve a desired result for the borrower or the lender. These can include an extension or loan modification, a forbearance agreement, a short sale agreement, a discounted payoff agreement, in addition to a deed-in-lieu agreement. In addition, if you're considering a deed-in-lieu agreement, there are so many different terms and provisions that have to be negotiated as part of that deed-in-lieu agreement. For example, one of the main points of negotiation is debt forgiveness, which gets even more complicated if there are guarantees in place for the loan, including both full recourse guarantees and non-recourse carve-out or bad boy guarantees. In addition, a deed-in-lieu is essentially the same as a real estate purchase and sale transaction, and there's a considerable amount of due diligence that's required and documents that will need to be prepared and also negotiated on behalf of both parties as part of the transaction. So it's strongly recommended that a borrower or a lender consult with their attorney when dealing with a defaulted loan situation as early in the process as possible, because there's so many issues and scenarios that will need to be considered even in advance of a loan default.
All right. So Richard just gave you the textbook reason why you need a lawyer. Let me tell you, as the guy on the street in this discussion, why you need a lawyer, right? Because you could potentially do your own dental work. You could potentially remove your own appendix, but you wouldn't try to do that stuff on your own. This is a complicated transaction. It's just as complicated as when you bought the property. Now you're essentially unwinding your purchase of the property, and you're doing it in a way where you don't want anything left undone. You don't want something coming back to bite you. That's the reason why you need an attorney. If you're considering a deed in lieu, the deed in lieu is going to, in almost all cases, be less expensive than going to the mat and fighting a foreclosure all the way through. It's probably going to be a situation where you're looking to save money, but where you save the money is not in the legal advice. You save the money in hiring the lawyer to get you out of extended litigation or get you out of extended proceedings and negotiations. So this is your opportunity to invest more in a lawyer to get a better deal. So you'll invest thousands so you can save hundreds of thousands, if not millions of dollars. So this is not something you want to do on your own, just like you don't want to cut your own hair, you don't want to do your own dental work, and you don't want to remove your own appendix. All right, so guys, if people want to reach out to you for help, what's the best way for them to get in touch with you? Jason, we'll start with you, and then Richard will go to you. What's the best way for folks to get a hold of you, Jason?
Sure. Best way is always going to be email, and that's at the letter J, Bergman, Bergman, at Benchmark, T as in title, A as in agency.com. You could also, of course, look up Benchmark Title Agency in White Plains, New York, click on my profile, and contact me that way by email or phone. Always available at area code 516-426-5670 for any questions relating to a deed in lieu of foreclosure for title insurance or for any other insured default remedy option, short sale or similar.
All right, so you probably see that information right there. It'll be down in the show notes as well. If you're looking for Jason, that's where you can get him. Richard, how do we get a hold of you?
Okay, with me, same thing, email. My email address is rim@rosenbergestis.com. That's Estis is spelled ESTIS. And I'm also reachable. You can call me on my direct dial at 212-551-8435.
All right, so you see that information there as well. It'll be down in the show notes for you also. This is the Inside Rosenberg and Estis show. Thank you for joining us today for this conversation about deeds in lieu of foreclosure. We'll see you back here again. Until next time, I'm Dave Lorenzo. Thanks for joining us today.